Hello, and welcome back to Coin Lady channel. It seems reasonable to conclude that Judge Torres is on Ripple's side in this instance. Looking at specific decisions, I do believe that Ripple has fared better than the SEC. This is especially true when it comes to consequential concerns. Now, this doesn't mean I'm convinced that Ripple can't fall short in some way. I still have a lot of faith in XRP's future, especially with regards to secondary market transactions, but it's realistic to assume they might have to pay a fine or something and receive a technical loss. So, we'll have to wait and see what unfolds. Whatever the case may be, it appears that Judge Torres generally favors the Ripple viewpoint. But the stance of Ripple? That bias wasn't there to begin with, though. She didn't know anything about the situation going in, but she quickly figured out that I am, in fact, guessing. I think she picked up on a lot of what we in the XRP community already knew about the SEC's sneakiness, sliminess, hypocrisy, and disgustingness. An XRP community attorney, Fred Rispoli, has said, it's easy to see why rulings have been breaking for Ripple. I'll explain things from his point of view. Despite the fact that some people, including some lawyers, have said, all the Hinman documents that dropped yesterday, no big deal, I'd like to elaborate on why I think otherwise. There are no shocking revelations either. For me, this is a major development. I'd want to elaborate on that. I do want to clarify something before I go any further. I come from no financial or legal background. You shouldn't buy or sell anything based on what I say or write because I am not a legal or financial advisor. Just a hobbyist here that occasionally posts films to YouTube on various crypto-related topics. I'd want to update you on some recent remarks made by attorney Fred Rispoli on this subject. Again, mind you, and it's fine, whatever your perspective is, some individuals are extremely thrilled with the discoveries from the Hinman connected emails and documents, and some aren't. He wrote the following. It's debatable, but I put myself in the camp that believes this to be true. I believe this to be the case since I believe that I had rather high standards for myself. In my position, I can confidently say that this is a significant net gain. In any case, that's just what I think. So, attorney Rispoli is currently in the field for work and will provide further details at a later time. But if you're feeling uninspired by the Hinman emails, it's important to keep your higher order thinking talents in mind. Unfortunately, this is all we have available for now. And probe by Congress or similar proceedings can now unearth a wealth of previously unavailable information. Consider what transpired after the speech. Surely somebody must have questioned Bill WTF. You disregarded our every warning. This is only the tip of the iceberg. As a result of the Ripple case, the SEC has lost all credibility. Since Netburn and Torres saw the emails and both realized the ramifications of what else presumably exists, it is easy to see why rulings have been breaking for Ripple, even though such conjecture will never appear in an order. Exactly. So, I agree with you that attorney Rispoli made a very good point. As I mentioned at the outset, both Judge Netburn and Judge Torres were given a clean slate while hearing the SEC's side of the Ripple case. I won't be looking for the truth. That is the role of judges. There is no doubt that they have acted fairly and impartially, as one would expect from a judge, and every evidence points in that direction. To what extent, then, should we be surprised that, at least in terms of the pretrial proceedings, Ripple has been successful thus far? They have realized that they are very bright people. They are very well versed in the same material as we are, perhaps even more so than you are. However, members of the XRP community are privy to all the underhanded dealings, discrepancies, hypocrisy, and doublespeak. What role do you think this will play in the SEC v. Ripple verdict? In my opinion, a definitive yes is likely to be the response. Around 76,000 XRP holders are being represented by Deaton, all of whom are pleading with him to do the right thing by investors. I agree, that's quite potent. And to keep an eye on that, because it's not only that. Let's be honest, I have close to 30 different types of cryptocurrency in my possession. True, XRP is the asset I hold the most of. It's the cryptocurrency I've been raving about the most for a long time, and for good reason. But it's not my only one, and I'm concerned about the others as well, because, as I've said for a long time now, I have no idea what Kim Jong-un will do to ensure the next target of an assault is. A few things have clicked for me, too. I also have custody of Algorand and Dash. After those, they've arrived. You spoiled brats, thank you not one bit. They're doing nothing but decreasing my wealth. And they do. They are definitely decreasing my wealth. That is something I have zero doubts about. But now that it's out there, people can actually use this information. On the other hand. But even if you didn't think so, and you should, how about the jury? As a whole, the XRP community did have a good idea of what was probably in there and how the concepts worked because of the context provided by previous case revelations. Sure. But what about the rest of the world who aren't necessarily paying as much attention as you are? Do you not think that contributes to the disdain and increased outrage of the general public? To me, it seems obvious that the answer is yes. That's the way it goes, though. That's why I value Warren Davidson and Emmer's contributions so much. The Republicans in the House have really proposed legislation to replace Gary Gensler as SEC chairman and to reform the agency's procedures. In a recent video, I emphasized this point. They are indeed acting in that manner. For the various reasons I listed above, as well as the president's veto power, I believe the likelihood of its passage is exactly zero. As a result, it has been met with criticism. Look at all this political posturing. Just shut your mouth, you idiot. Do you realize the impact that has on people's opinions of you? Do you get the significance of public opinion and the importance of spreading the word? Let's give Warren Davidson credit where credit is due. He's the one who initiated this. He came up with it first. He has made numerous national television appearances to promote his ideas. And now you're going to tell me that this is all just pointless political theater? No way, not at all. It's a means of communication. It serves a purpose. So, even if he doesn't think that, it's probably going to pass anyhow. That's not the point. You go out there and give it your all. Yeah, that's the whole point. The person asking for Fred was called Fred. Yeah, you nailed it. Where Fred is. It's cool that Fred asked Fred a question about Fred. In what ways do Hinman's communications shed light on XRP's mixed security/non-security status? While these may be useful for providing proper warning, they do not inform us what XRP currently is. Although I disagree that XRP is a security, I don't see how this helps anyone but the SEC's reputation. And so, Attorney Rispoli chimed in, that's it, fellow Fred. Some people seem to have forgotten why Netburn and Torres even allowed manufacturing to begin with. The problem goes beyond mere aesthetics. This is due to ineptitude, malice, cronyism, and power abuse. Keep in mind that these were not made public until after Hinman's removal. It's conceivable that these emails ruined his deposition. Dead on. Someone who can see the value in this is finally here. Absolutely. I agree wholeheartedly with what you've said. Absolutely. Dead on. Now, there is also the viewpoint of attorney Gabriel Shapiro, who yesterday referred to the Hinman revealed here, if you will, called it a nothing burger. That's the same term he used. This is quite acceptable, by the way. I enjoy his outlook. I must respectfully disagree. Totally agree. If anything, this will strengthen Ripple's fair notice argument in court. I'd rather not discuss that further. I elaborated on that point at length the day before. That's a point on which we can agree. However, many of the reasons why this is a non-issue were stated in detail yesterday. However, allow me to elaborate. The attorney for Gabriel Shapiro, Shapiro's point of view in this case, admits that the SEC is gross and disgusting and smells bad. Here is what lawyer Shapiro had to say about it. I think we can all agree that the emails from Hinman have not decided the fate of Ripple. Security policy measures. The entire field of cryptography has been a shambles. Before Gensler, there was no nebulous morphine non-guideline to invite arbitrary legal application. Token by token, despite detailed assessments of facts and situations, having arcane priests decide these questions every time is impossible. Congress must take the lead in developing a comprehensive crypto regulatory framework that is both practical and understandable. I couldn't agree with you more now. Even if I disagree with him that this is a non-issue, I can comprehend his viewpoint. I think he's dead on with this. However, this relates back to what I was stating before. Spread the word if you want Congress to take that stance. Indeed, we are. Indeed, we are. Indeed, we are. It will happen eventually. My fellow YouTuber, Jungle Inc., has an interesting take on things, and I think he's spot on. This is exactly in line with what I've been thinking, therefore I felt it was important to give credit where it's due and give a shout out. The words of Jungle Inc., the impact of the Hinman documents was greater than initially believed. The SEC admits that Hinman was relying on his own discretion rather than the law while conducting his examinations. They acknowledge this adds unnecessary complexity. If a token is being used, then it is not a security, as admitted by SEC, liquidity needs can be met quickly. Even if that were the case, Ripple has already halted its programmatic sales, which, as far as I can understand, basically means any sale of XRP unrelated to on-demand liquidity. In 2019, I believe, Ripple put a hold on its programmatic sales. So long as they can use XRP for on-demand liquidity and we have open secondary markets for XRP transactions for everyone else, that's a victory even if they never return. I would consider that a huge victory for Ripple even if it means a technical loss. The point is not that I care if Ripple wins or loses. I'm simply saying that if that scenario played out, even if Ripple came out on the losing end, they'd still be overjoyed. It's fine if they have to pay a lot of money, actually. The jungle still rages on. The SEC says they are unsure about Ethereum and may decide to reverse course in the future. In case you missed it, yesterday there was some feedback on a draft of Hinman's Ethereum free pass speech, in which they said things like, "Yeah, are you sure you want to include ETH in here?" I'm paraphrasing, but you know that could limit our adaptability. In the future, we might decide to go after Ethan. That's going to take some extra effort on your part. That's the takeaway I got from it. However, given that Bill Hinman named the email thread Ether speech, it's clear he was never going to change his mind. Nothing about crypto security, digital asset classes, the intricacies of securities, or any other such blah blah blah. Speech in the ether. That sounds suspicious to me. And yet, he is correct. Actually, they do recognize it. The article continues by claiming that the SEC has acknowledged the existence of regulatory gaps over which it may not have jurisdiction. To help direct the market, SEC posted the Hinman speech on its website. Clayton referred the market directly to this address. The entirety of the crypto industry adapted to fit his standards. If the SEC wants to change course, it should do so through interpretive guidance rather than legal action. That seems about right to me. So, if you're going to call that a non-issue, I'll have to respectfully disagree with you again. That burger must be something, in my opinion. Even the word nothing bothers me. My entire life, I've always just saying. There just doesn't seem to be anything better. It sounds like an attempt at cleverness from someone who isn't particularly clever. And then, finally, people started using that expression. I don't. It's not to my taste. You know, that's a pet gripe of mine, and my 8-year-old terrier mix is my first pet peeve. That's my tiny dog, he's very cute. This, though, is yet another of my pet peeves. No-name sandwich, a no-brainer. I pray that I am never forced to use it. My guess is no. Alright, if I do it that way. The only action required is to cancel your subscription. Believe me, I comprehend. Believe me, I comprehend. Simply put, it's a stupid phrase. However, the SEC is again openly stating, in this case, literally, that there exist regulatory gaps. It's also possible that they lack complete control over certain aspects. Do you not think that will be helpful in future prosecutions? Because, once again, they keep hurting my net worth, and I'm sick of it. I'm taking a long-term view and considering the safety of the remainder of my crypto. I find them repulsive and must constantly lash out verbally against their stupidity. I'm glad to see people in our community and the wider crypto community speaking out against this. In the long run, it does matter. We've reached a tipping point where those in authority can no longer disregard our demands, after all. The only question is whether or not we are willing to go to great lengths to bring about the essential reforms in Congress and the administration. Not opposed to that idea either. I'll just let you know that. No, I don't give out financial advice. No, I suppose not. No, I don't give out financial advice. Nothing I say or write should be used as a basis for making financial decisions. Please like and subscribe my channel. See you later, bye.